Thank you, Josh, for such a lovely introduction. I almost didn't recognize myself. It's a great pleasure to be with you here today. It's always a privilege to come into this community because you guys push my own thinking in new directions every time I interact with you. So I end up learning far more than I ever impart in terms of knowledge to you guys. So with that, I'm going to share a few thoughts, hopefully playing on the themes that were emerging from the other keynotes, as well as some of the talks and some of the conversations that I've been having over lunch and liquor with many of you. So, without further ado, to start, I unfortunately need to do this. So there'll be some foul humor, and you'll understand why I chose the word foul more clearly in a minute. So I do need to disclaim that my opinions are definitely mine. I'm currently serving as the Senior Policy Advisor for Privacy and Security to the Federal Trade Commission. These are my views as an academic. They're not intended to reflect any sort of enforcement priorities or the opinions of the FTC. Okay? Clear? Excellent. I'm a law professor. That's what I do. I also used to be a corporate lawyer, and I represented companies who were struggling with InfoSec issues. So that's my background. So I've been on both the corporate side of this and now on the academic side of it. And I have a few opinions, as you'll see. So here's what we're going to talk about. Hence my foul humor as the third keynote. I felt I needed to ramp it up a notch. We will be discussing chickens for substantive purposes, and we will be discussing corporate governance. And corporate governance is a term that some of you may be familiar with, but some of you may not have heard it all that frequently before. And I'd like to introduce you to this term because it can be your friend, in particular in winning the ear of key decision makers inside enterprises that are struggling to properly incorporate security into their day-to-day operations. Okay, I frequently hear this question. Why is the law so slow / suboptimal / challenged / other words that I wasn't going to put in writing in dealing with corporate InfoSec issues? So I'd like to give you a little bit of a law professor perspective on this. Here's part of why it's so challenging for legislators, lawyers, academics, business people to understand these risk dynamics around information. Information security law sits at the intersection of many other bodies of law. Some of these bodies of law are federal. Some of these bodies of law are state. And some of these bodies of law are both state and federal. That means we have a very complex picture pushing on businesses and individuals as they interact with information, use, storage, sharing, etc. So from my perspective, the new data breach notification legislation that's happened in the last decade, that's a form of corporate law. But that framing itself is not something that is necessarily intuitive to even lawyers who work in this space necessarily. And we see contract law having subfields like employment law, which impacts many of you in this room. Layer onto that tort liability, meaning civil wrongs, and when one private citizen or company can sue another private citizen or company, which is primarily a state-based regime. Criminal law, international implications, and constitutional law, we end up with many circles on that slide, right? And so to have mastery over that space presents a challenge to even the most sophisticated general counsel and even the most sophisticated business makers, decision makers inside businesses. So, what we're seeing evolving and what has existed for a long time in law is the idea of reasonable person standards. So reasonableness is evolving as the hallmark of this space, and it exists in various forms in each of these bodies of law that I've identified already. And so the idea of harnessing the question of what would a reasonable decision maker do in this circumstance, that's a touchstone that will resonate with decision makers. When we're talking about questions of legal liability, we're talking about floors of conduct. Personally, I am entirely opposed to regulatorily stipulating which technologies should win debates. I think that's a recipe for failure because technology advances at a pace that's not possible for law to keep up with. But what you guys do, the best practice is that's the ceiling of conduct. And so it's somewhere in this conversation between the ceiling and the floor that change happens. As you guys push best practices up, law gets to raise that floor. And that's why reasonableness works, because it's the floor that we're talking about. The people should know better than this. Think about it in terms of a slick floor in a restaurant. This is a very traditional example. The floor is the property of the restaurant. The people who are maintaining the restaurant are in a better position to know that that floor is slick. There are reasonable processes in place for cleaning that restroom, one would hope. So if someone gets hurt in that restroom, we traditionally have found the owner of those premises to hold responsibility to the injured party. It's that idea of reasonable conduct in context that we're seeing filtering into information security law contexts as well. All right. So you're saying, it's hopeless. I'm depressing you guys, right? And it's first thing in the morning and your coffee hasn't even kicked in. No. We are doing already reasonably well, such a lawyer word, reasonably well with these reasonableness standards, and expect more. But progress is happening, believe it or not. It seems, I know from the outside, sometimes it's painfully slow, but there has been in the last decade tremendous legal progress in legal pace on these issues. All right. Am I saying you can all stop worrying? No, absolutely not. Why? There's a chicken issue. I'm calling this, for your amusement, the glorious chickens problem. Okay. So I'm framing it this way to try to craft a common language for you to easily be able to connect with perhaps the suboptimally informed lawyers that you encounter. Okay? This list of characteristics, being mostly self-taught, looking for ways to bend rules and getting existing systems to do what you need them to toward accomplishing goals, being an elite, highly compensated, very smart group, and being core to successful functioning of companies on a day-to-day basis. This describes both lawyers and information security professionals. So there's a common frame of reference here. And part of the challenge is sometimes recognizing when you need to reach for help and when to blend your knowledge base with another knowledge base. And so reaching out to some of the attorneys that you encounter on a day-to-day basis and starting this reciprocal relationship can truly be a game changer in terms of pushing corporate policy forward and social policy forward. Now here's a challenge that I will perhaps push back a little bit on previous commentators. There is an importance to word choice in legal spaces. And so sometimes in new policy areas, terms become the default or the most popular term, not because of a reasoned choice, but just sort of viral spread. So while engaging with those default terms, and one of those terms may be the term cyber, which by its standalone nature and on its face, it implicitly ignores the important aspects of physical security, for example, right? When engaging with those existing terms, teach new ones as well. So while Congress may enjoy using the term cyber or cybersecurity, many of the government agencies that are involved in InfoSec do not use that term as their primary descriptive. For the Federal Trade Commission, the line of cases are called data security cases, for example. So know your audience and help bring them along into the formalized language of this community, because the specificity of the terms matters. Why? In part because conceding to vague terms will result in problems down the road because of those vague circumstances. And here we're back to chickens. okay? This is my favorite contracts case. I teach it to my first-year law students when I teach contracts. This is a case where two companies ended up in court over the meaning of the word chicken, okay? It was a German company and a US company. Actually, it was a Swiss company that spoke primarily German because it was Schweizerdeutsch. Anyway, so German language and US and English language. And because of the nuance in the translation and in the state of the art of chicken rearing, they ended up in court fighting over the meaning of the word chicken. So I tell you about chickens to kind of highlight that words that sometimes have a superficially apparent meaning may nevertheless have implications in context of the state of the art of a different profession. And so keeping true to your own profession's defined terms is a way to mitigate risk of having the conversation end up going in an undesirable direction down the road because of your concession to a different term. So it's just a cautionary note that I'll raise. All right, so how would I advise reaching out and teaching lawyers about InfoSec as you're making new friends and influencing people? So for better or worse, and this is brutal honesty that I say lovingly about my own profession, and it's improved a lot in the last decade. The people, on average, in the legal community know much more about the importance of information management than they did when I started writing in this field. But I think, honestly, if you chop the last decade of knowledge off of yourself, and then try to explain that, what's happened in those last 10 years, and bring people up to speed in that way. You know, not in a condescending way, of course, but just assume that knowledge level, and then when they demonstrate more, no problem, ramp it up. But this is a quick kind of thumbnail way to make sure that perhaps the lawyer you're speaking with is on the same page with you. Also, the slang of this community, which is charming, and I incorporate it myself and enjoy it. The terminology that business and law use sometimes a little more formal, so the correct InfoSec formal terms should definitely be introduced every chance you get to decision makers, but maybe watch the slang a little bit, because I've had people ask me, this person said X, what does that mean? I felt really stupid, right? And the goal is to make the other side of the equation feel challenged, but not stupid. Okay, so here's my other kind of, for whatever it's worth, anecdotal indicator of the speed of legal change. I'm behind this community, right? You guys are ahead of me. I wrote an article in 2003, 2005 about how securities regulation needs to change to consider information risk in InfoSec. The Securities and Exchange Commission came out with guidance mirroring those recommendations in 2011. Okay, so count those years, right? So that gives you a benchmark to kind of conceptualize what the pace of change may be in at least one context. So, here are my sort of three middle of the presentation points so far. So find the commonalities with the seemingly dissimilar but yet interested in subject matter nerdy lawyers you run into and business people. Teach them. But my next challenge to you is to borrow some of their frameworks that have been effective in getting things done. And that's what I'm going to introduce in the rest of this talk, one of those frameworks. You'll notice from inside your organizations, the legal departments tend to be pretty stable and don't get pushed around a lot, right? One of the key reasons for that is the notion of corporate governance. So corporate governance, you'll get different definitions from different people, but essentially it's the set of rules, norms, obligations, conduct that facilitates and crafts the day-to-day management of companies. So here's a quote that might prove useful in one of those conversations. And this was in yesterday's Wall Street Journal, so hot off the presses. And yeah, I'm kind of partial to it because it's mine, but you should still use it. because I think it's really right. So information security and information risk really, as we all know, it's critical to every piece of an organization, and particularly if you have an organization that relies on intangible assets, right? If your crown jewels are walking out the door, if your R&D is being lifted by your competitors because of inadequate security, you can't possibly know what that R&D is still worth. You can't possibly be reporting it accurately on your balance sheets. You can't possibly be communicating about its prospects in the market with full accuracy. So these are some of those types of concerns in legal speak. And I wrote an article on this stuff in 2009, so, you know, do the math, and probably around 2015, maybe we'll get some traction with these ideas. Okay. So one of the follow-up questions that I generally get as a corporate lawyer person, and someone who teaches in this space, so why aren't directors and officers just handling this? Why aren't they realizing the severity of the problem, and why aren't they engaged in the management of these assets in an appropriately careful way? And this was something that, frankly, confused me, and I started researching it, and then the conclusions that I reached, which I'll share with you today, are part of the reason why I'm encouraging you to engage with the legal department. So fiduciary duties, which many of you are undoubtedly familiar with, are sort of a tough fit for information security concerns. Duties of care, duties of loyalty, duties of good faith, and the business judgment rule, they all require reasonable care and conduct on the part of officers and directors in order to sort of get the shelter of the business judgment rule. But they haven't been expressly extended in a way that's logical for databases and other information assets. Why? Well, part of this is a historical legal approach that is falling apart a little bit. There's what I'm calling a time interval problem with these fragile assets. And specifically, when you are challenging as a shareholder a corporate decision, you need to be able to point to a decision. But that's not how information security problems occur, right? It's slow leakage, it's failure to be vigilant, it's not having the good auditing process in place, and so it's hard for a direct challenge to happen because the discrete transaction that the law is looking for in order to have a supervisory role, you never get that discrete transaction at the appropriate level for a legal challenge. The other dynamic under current fiduciary duty and business judgment rule laws is that in general you need a grossly negligent act of commission by the officers and directors. They have to do something really bad, okay? But again, that's not quite the perfect fit for an information security inquiry because it's more frequently acts of omission. It's not investigating that breach. It's not having reasonably trained staff in place. It's not listening to your CISO when she or he is saying, hey, we've got a problem. This is a major legal risk. This is a major consumer risk. This is a bad PR scene waiting to happen. Let's do something about it. Ignoring that doesn't quite fall under traditional notions of fiduciary duties and business judgment. So that leads to the idea that maybe it's good to have collaborators fight your battles with you and for you. And one of the natural places for this is the General Counsel's office. Why? In part because General Counsel is used to thinking about things that haven't happened yet. We train law students to anticipate risk. We teach them to avoid harming people and to think about avoiding the financial losses and the bad consequences in conduct that has not yet occurred. So here are a few ideas about ways that you can sort of concretely engage with and add value to your general counsel's life. So as I said, they understand the risk avoidance mentality right away. So that's going to be a natural fit for you. The idea of financial data potentially being manipulated as it's being reported in securities filings, that's going to be a really palpable, eye-opening concern for lawyers who haven't yet thought through the implications of information integrity inside the enterprise in that way. So securities laws are your friends in this case in making this point. Next, the idea about research and development and intellectual property walking out the door, unknown, unseen. This is something else that counsel will certainly be interested in. And note, when I say IP, I don't mean your kind of IP. I mean my kind of IP. I mean intellectual property, right? So there's a little translation tidbit. When you say IP to a lawyer, they're going to assume intellectual property. And when they say IP to you, you should, realize that they mean IP, and they may not be necessarily connecting with the tech end of it. Okay. The information security professionals inside an organization are probably in one of the best positions to detect rogue employee behaviors. That's something that corporate counsel worries about constantly. And in enabling them with good information to potentially plan for that key act of corporate espionage that could undermine the next 5 years of productivity in the enterprise, et cetera, that certainly will be very useful and win you the love of the counsel's office. Accurate marketing and shareholder communications. Making promises about the existence and quality of services, particularly in enterprises that are heavily technology reliant. Those need to be substantiated and accurate. And so those marketing claims, sticking to the technology reality of business capability, that's something that general counsel will be interested in and be aware of because of possible enforcement. Shareholder communications, similarly, another securities issue. And finally, one that's even perhaps a little tangential, but yet could be critically important, because I've heard of deals ending in tremendous disaster because of this relatively recently. As the InfoSec experts, you're in a unique position to assist corporate counsel and outside counsel in evaluating acquisition targets and their systems. And so if there's a target for an acquisition that has been engaging in really suboptimal security practices, getting them up to speed once they're acquired may cost millions of dollars. And that's a loss that your employer may not be anticipating because their lawyers may not be anticipating it. The categories of risk that are sort of big ticket red flag items for M&A attorneys include things like tax liability, environmental liability, employee benefits liability. Those are maybe the big three that all of us who do or did M&A worry about and get experts called in. With information risk, the experts aren't really the attorneys themselves, it's you guys. And so making yourself available to help with diligence in an acquisition, that could be tremendously valuable to a general counsel's office. And by winning their attention and their favor, they'll obviously be quick to fight for you, your budgets, your staff, and your advice being taken very aggressively to heart in future management decisions. Okay, so I will leave it there and leave room for questions, intentionally leaving lots of time because I hope you all will engage with this. If you are interested in reading 75 plus pages of legal minutia, lots of articles for you at that link. So thank you for your attention.